This is Caught in the Act with Tim Clarke.
Welcome back. Stewart Sinclair Gorham is a truly terrible, horrible, no good, very bad human being. In fact, he might be Western Australia's most dangerous man. And if you were ever in a position to ask him, which would not be a position you would ever want to be in, he would also eagerly admit that himself. Gorham is now 54 years old. He proudly boasts that only 100 days have been spent in the community in the past 33 of those years. That time inside has been for despicable crimes, mostly sexual violence against young men, the last of which was just 12 years old. Gorham also insists the rest of his days on earth should be spent locked up. If they are not, he has told numerous experts he will rape and kill at the very first opportunity he gets, even laying out a plan to ambush and then torture in the prison car park. This week on Caught in the Act, we will outline the hideous history of Stewart Gorham, which is so bad that even he says he should never be free again. And we will also explore the controversial and continuing debate over detaining people after their sentences are served, and whether a balance is being struck between protecting the public and punishing beyond the pale. And just a warning before we begin, this episode obviously contains details of sexual assault, child sexual assault, and other themes that might be distressing. So please take that into account if you want to continue listening. Joining me for all of that is a friend of the podcast and one of WA's most recognisable legal minds and voices, Tom Percy KC. Tom, thanks again for joining us.
Yeah, good morning, Tim. How are you?
I'm very well, mate. Very well. So, as Stewart Gorham tells his own personal history, he was aged just 10 when he was removed from his family for burning down a house and then attempting to kill a man he met on the street. After being transferred to a boarding school, he then says he tried to stab the principal before being introduced to heroin by his father, aged 13. These, obviously, are unimaginable claims. They might well be entirely fictional ones. But after some of the other crimes Gorham has committed and admitted to over the years, that early life cannot quite be discounted. As an adult, Gorham has been convicted of 17 serious offences, the first of which happened in 1988 when he was just 19 in Melbourne. His victims were just 16. The first head-butted more than a dozen times and thrown against a window. The second lured away from his friends, bashed, strangled, sexually assaulted, and then tangled up in barbed wire fence as he tried to escape. For that, Gorham got 18 months in a youth training centre. Less than 2 years later, in late 1990, Gorham was in Perth, in a hostel and apparently under little supervision. That was why he was able to befriend a 17-year-old resident with the promise of wine and a lesson on how to survive on the streets. After being lured to a park, the teenager was punched unconscious and then raped in a toilet block. As the victim came to, he was knocked out again and then again. This time, WA's Supreme Court jailed Gorham for 5.5 years. Tom, in those years and for several years after, the courts had fewer options in dealing with serious repeat offenders. I think it's probably fair to say.
I think that's so. I mean, for many years we just live with the concept of people doing their time, either being paroled or doing their full time and then getting out on the streets. And, over time it appeared that there needed to be some more supervisory functions for the courts to perform, making an assessment of people who were scheduled to be released and just making sure that they were going to be safe or they didn't need further conditions when they were released. Now, that wasn't a mechanism that was open to the courts in days gone by. But I can't see that there's any real problem with that.
No. And also sort of in bygone years, the maximum sentences were also generally less, meaning sentencings overall were lower. But on the flip side, for the most serious, judges did have the option of an indefinite jail term for crimes other than murder.
Well, that's right. They did have the power to put a non-finite sentence on people, but it was very rarely used, and I think it met with the disapproval of the High Court on more than one occasion. So it was not something that I've never had anyone get what we used to refer to as the key, as you're throwing away the key, and that was actually the most feared thing in prisons, that someone might one day get the key, because you can do that. I'm not sure that there is anyone in jail now who's subject to that regime.
Well, yeah, I can only think of one in recent times, which was a particularly savage murder of some children and a mother-in-law that was handed the indefinite sort of life term on top of the actual life term that you get for murder. But I mean, quite famously, the Claremont serial killer was asked for that he would get the indefinite life term, but Justice Hall turned that down. So I suppose that shows even now, I mean, even more now, how rare it is for someone to be imprisoned for the rest of their natural life.
Yeah. Look, I think it's more common in the eastern states. You quite often get people who are jailed without any prospect of parole, particularly in New South Wales. But we don't see it very often here.
Why do you think that is? The judges tougher on crime on the eastern seaboard, Tom?
Well, I think they have more specific legislation where it allows that to happen. But I know in the case of the Greenough killer, Mitchell, he went to the High Court after being handed a never-to-be-released sentence, and he won that. And the court was of the view that, look, the people who should make that decision, not us, will be dead and gone by the time this all comes up. And he may well be a completely different person. It's not to say he will be, but his case should be determined by people in the future at the relevant time rather than someone 30, 40 years in the past.
And I know me and thee have had this debate on a couple of occasions. There are cases that are de facto indefinite terms, and you've spoken publicly about one of those, Catherine Burney, who, although she has long since served her sentence, will, practically speaking, probably never be released because, as you've said to me before, which Attorney General is ever going to put their signature to that?
Yeah, that's right. I mean, just because you've got a non-parole period, it doesn't mean you're going to get out. If someone says, 22-year minimum, and you hear people say that on the news, he will serve 22 years before he's eligible for parole. Well, that's just a fanciful, aspirational figure for the bloke to think about. But there's no guarantee at all he's going to get out after that life. Means they can, all things being equal, if necessary, keep him there for life.
Well, in January 1999, Gorham was on the streets again, and that's when he struck again with another victim, this time aged 30, a fellow resident at a rehab centre. The pair had snuck out to buy a couple of flagons of sherry. They got them stashed and then later went back to get trashed. As they did, Gorham thought his new friend was getting cheeky, so he bashed him so hard he knocked him out and broke his jaw. Another 5.5-year stretch. And then, in 2004, on the streets again, Gorham's escalation intensified. By this time, he is 34. The young boy he comes across on the bike was just 12. After they walked to a liquor store, Gorham bought the booze and then told the tale, which allowed him to separate that 12-year-old from his friends and get him to his home. And that's where the nightmare began.
It happened lunchtime Saturday. Police will allege the 35-year-old managed to lure his 12-year-old victim away from these shops in Willagee by saying he was new to the area and had lost his way, offering $100 to whoever could lead him home. It's alleged the man then locked his child victim in this house and forced him to perform sexual acts. At one stage, the man held a knife to the boy's throat and threatened to kill him. After more than 5 hours, the boy managed to run home. His mother phoned police.
The door was locked, padlocked in fact, and a knife produced. The threats began for the boy to strip and shower. He was told by Gorham he had fallen into his web. And, like a spider, maybe a rock spider, with a fly, the terrified boy was toyed with, tortured and repeatedly sexually assaulted. Eventually, almost miraculously, he was let go, and Gorham was soon locked up, having only been out of prison for 1 month before preying on that innocent, unsuspecting victim. Tom, going back to the early 2000s, what were the supervision regimes like surrounding sort of serious offenders compared to now?
Well, going back to like the 70s and 80s when I first started practice, there were none. And when you did your time, you got out. Unfortunately, the problem was, as it still is that there's no real halfway houses here for people who get out.
Mm-hmm.
They go straight out into the mainstream community, and particularly ones who are denied parole. At least if they're granted parole, sure, they get out a bit earlier, and that sits uneasily with some people. It sounds like they're getting out of it easy. But at least they're subject to supervision. And for a couple of years, the worst of it can perhaps be managed. But people who get out, who do their full term, no parole, get out, they come and live right next door to you, completely unsupervised. And that was sometimes a problem. Mm. Now, I don't say it was a problem to the extent that crime is in the community these days. I mean, we've got a lot of other things operating now, methamphetamine and, a generation or two of very bad parenting and education and things like that, which has contributed towards the crime rate. Not saying people were much better intrinsically in those days, but we did seem to have a lot less crime, and we didn't have the same sort of harshness of laws either. So it's a bit of an interesting dichotomy. But it came a time, I think, when Parliament had to say, well, we need something more than parole. We need to deal with people who are going to get out and they're not going to be on parole. We need a judge to have another look at them. Sure, the sentencing judge tailored a sentence to what he or she thought was appropriate for the circumstances, but the reports from the internal prison people, the counsellors, psychiatrists, the prison authorities, indicate that this man or woman is not really fit for release. So there had to be a mechanism whereby that occurred, and that's where we have the Dangerous Sexual Offenders Act and now the Dangerous Offenders Act.
And there are several cases that are cited for instigating those originally the dangerous sex offender laws, which we'll come to in a minute. From reading back in the archives, Gorham was certainly one of those, because there was public outrage when it was discovered, A, how long he'd been out of prison before he offended again, B, obviously the nature of the crime against a child, but C, the fact that he'd been placed basically, right, as you say, right back in the heart of a community with apparently little or no proper supervision and monitoring.
Yeah, well, look, I often ask people who say to me, why should this guy get out early? Why? And they read something in them, why should he get out early? Why give him parole? The answer is, all right, well, let's imagine he's going to go and live next door to you. Would you rather him be on parole, or would you prefer him to be scot-free? Because sooner or later, they're going to get out.
Yeah. And that is always, 98% of the sentencings that I attend, certainly in district court, they always say that. Parole is almost never opposed by prosecutors who are, obviously trying to send people away, because, as you say, the other option is nothing. No monitoring.
Settle them out a bit early under supervision, than just give them free rein to go out and roam the streets, completely unfettered basis. But I think the dangerous sex offender legislation achieves its purpose. It's harsh. And sometimes I think it just sets people up for a fall. I mean, when they have like no alcohol conditions, can't go to licensed premises, all of those sort of things. Some of those are excessive.
Yeah.
People just can't comply. I'm sure I couldn't comply with half of the conditions that those guys get released on.
Yeah, I mean, The community outrage that I was just about to ask you about, I mean, we see it quite a lot when people like me report on these sort of dangerous offenders being released, and it's a flippant throwaway line usually at the end of the story. There's 54 conditions or whatever, but if you actually read through them, some of them are no internet, no phone. You've got to report any new relationships, whether they be sexual or not, to your CCO. I mean, they can be quite harsh, and I often, and you've probably often made those arguments. Well, you're setting this offender up to fail because it's almost impossible to comply.
Yeah, luckily I don't get asked to go down and do many of those, but on the occasions that I have found the conditions to be oppressive. And unnecessary. If someone has set their mind to reoffending when they get out, and they've been in prison by then for a long time, then they'll offend anyway. It doesn't really matter because they know what prison's like. They know the risks they're taking. If they genuinely want to stay out, they'll stay out of trouble of their own volition. No conditions imposed by a Supreme Court judge are really going to assist in that regard.
And community outrage, in another sense, I mean, over your years of practice, do you feel, I mean, and judges are always, and Supreme Court judges in particular, are always supposed to be, immune to the vagaries of the internet and social media and all that. But do you think as humans, it's impossible for them to sometimes ignore those headlines when it comes to either making a decision to release or making the decision on how long to lock up for?
An old judge once said to me when I was leading a line of questioning, he said, "Mr. Percy, we judges are not made of stone." And that's true. They are susceptible, and when you go down a case where you've got some degree of high moral ground or the person's not an entirely bad person, your chances of being acquitted or getting a better result are far better than when the person is actually an ogre. Irrespective of the crime, you can separate the crime from the person. If the person is a genuinely bad person, your chances of getting off are very remote, irrespective of the type of evidence there is. Similarly on appeal, judges, I think, are susceptible, at least subconsciously, to what the people will think, how this is going to be reported in the paper, what it'll be like on TV. And I think if they know that this is going to be a cause célèbre for some time to come, and there's a fair chance that they'll be pilloried for not making a decision which is in accordance with public standards rather than in accordance with the law, that must be a matter that plays on their mind. I've yet to find one judge who will ever admit that to me, even privately, but I suspect it's true.
Well, in this case of Stewart Gorham, he swiftly admitted he was the man who had inflicted that sadistic 6-hour attack on that schoolboy. 7 counts of aggravated rape, 3 of indecent dealing, 2 threats to kill, assault and kidnap. And prosecutor Carmel Barber-Gallo urged the court and the judge to lock Gorham up for life. Incredibly, Gorham himself agreed, or at least did not oppose that application. And he told a psychiatrist he knew he was a dangerous person and that jail was one of his favourite places because he could easily get sex and drugs in there. He asks Your Honour to lock him up for as long as possible. His lawyer, Laurie Levy, told the court. But despite all those opinions and all the community outrage, and also conceding no treatment existed for Gorham's particular set of sick skills, Judge Philip Eaton declined to make the ultimate call to jail forever, or even come near to the maximum of 20 years. Judge Eaton reached a term of 14.5 years, while stating the state, if it wish, could later apply to have his release blocked under WA's Dangerous Sexual Offenders Act. There's no way he should be released back into the community, Prosecutor Barber-Gallo confirmed. So we will look at it again in 13 years and 6 months. Tom, that dangerous sex offenders laws were brought in for offenders, precisely like Gorham, with the view of considering whether they should be released after their sentence is finished. And it's probably going to be an unpopular opinion, and it is mine, but it is also borne out by statistics. Those DSO laws largely worked in terms of protecting the public from serious reoffending. Would you agree with that?
Not really. I think that they're a step in the right direction, but whether they work is another question, whether they'd work on someone like Gorham if he ever got out. And they don't work for blokes like that. And there are some people that I know people have acted for who I have really grave doubts about whether or not they will be effective. I think they're popular. It shows the community that the government and the courts are doing something to protect them. But if someone's minded to reoffend, they just will. And if they're minded to fool parole authorities and get released, or they can pull one over a judge by showing all the intents and purposes of being rehabilitated and manage to get out, albeit on conditions, they'll reoffend if they want to. There's no guarantees. And I think that's why, even though someone like Gorham is sui generis, as we say in the law, in a category of his own, and I think you'd probably agree, he really is in a category of his own. I've never heard submissions like that made before. You're right, he wants to be locked up for as long as possible. I mean, that just is bizarre. And I think the benefit of those dangerous sex offender laws is that you can have a look at the person 13 and a half years down the track, as someone will do with Gorham. It's a bit hard for a judge to say, sitting there in 2000, what he's going to be like in 2014, or sitting there today, what he's going to be like in 2050. So I think it's a good idea to have a judge have a look at him at the time, with access to all the reports and the information that they have from the prison authorities, and make an assessment then. If it indicates that he's just not suitable for release, even with the most stringent conditions, they can say, we'll come back in 2 years and we'll have another look. I think that's fair enough.
Yeah. And you've said it there. I mean, you see it very rarely in the courts, but it's very rare that someone will sit in the dock and say, I don't want to get out. I need more time inside to get better, or to improve myself. But I mean, it does happen. Have you had clients give you those instructions in the past?
No, I never had anything like that. What I've sometimes had is saying, look, I don't want parole. Don't make an application for parole.
Right.
I said, well, you'll get it 2 years earlier. I don't want it because being on parole is a nightmare. I only reoffend and they put me back in. I want to go. I want to have a clean slate when I get out. I'll do the extra 2 years. So I've had people often say that to me, and even when they're in jail, if a judge makes an order for parole, some of them say, look, I don't want parole. They don't make an application to the parole board. They just do their time. And when they get out, they feel liberated. A lot of people, when they get out and they're on parole, they feel as though it's an enormous restriction on them, and you're not being able to go to a hotel or mix with a group of friends who might have convictions and things like that. Is not something that's suitable for them, and they're happy to do the extra time.
And in this case, obviously, the judge didn't take into account his client's wishes. Do you think that's fair to discount them completely, or is it, as always, you think in that case it'd just be a balancing act of, well, the ultimate decision is mine, not yours?
Well, it was an interesting cast, wasn't it, in that case? Both the prosecutor and the defence lawyer are now senior judges of the district court themselves.
Colleagues, yes.
And their submissions are only that. The judge is sworn to administer the matter according to law, and if it appears to him that a decision as to ultimate release of the person is best made by someone further down the track, then that's what they're going to do. And I think in the back of their mind is always that decision of the High Court in Mitchell, where that Greenough murder we were talking about, they said, look, the decision as to whether he should get out ever is probably a decision for someone in another generation to us.
And when it comes to post-sentence monitoring and restrictions, as you've talked about. In the past, you've pointed out that serious drug offenders, those major type dealers and killers, they don't have anything like that scrutiny when they get released, or they didn't used to. Does that speak to the what I'll call the politics of pedophilia, that there is nothing to lose when politicians, take on that particular set of offending?
Well, that's right. I mean, there is in the community, in the public psyche, at any time a bête noire or a black beast of contention, and the politicians hone in on that for political capital. And it was obviously pedophiles and sex offenders at one stage, and they just let all the other really, really dangerous people not be subject to that regime at all. But I think that's sort of closed now, and they've knocked that off. But, I think there was perhaps a misguided thought in the community that people can really rehabilitate from most crimes, other than if you're a pedophile. There's no coming back from that. You either are or you aren't, and you're incorrigible. I don't believe that. I've seen people rehabilitate and toe the line after they are released, and they live comfortably in the community very quietly and never reoffend, irrespective of what the crime is. I don't think you can say as a blanket rule that pedophiles never, ever rehabilitate and always constitute a danger to the public.
Well, in the case of Stewart Gorham, I don't think that is the case, because even after that 14.5-year sentence, he wasn't quite done. On remand, in protective custody at Hakea Prison, he befriended a younger, weaker prisoner, isolated him in a cell, and sexually assaulted him, which earned him another 4 years on top, and a possible release date of February last year. As promised by Ms. Barbara Gallo more than a decade ago, the DPP were on the steps of the court months before that date loomed, armed with an application to keep Stewart Gorham inside. Through that process, the state's Supreme Court is first asked to determine whether a significant risk exists to the community if the prison doors are opened. And then an interim order can be put in place until a full hearing can happen. At that full hearing, reports from prison authorities, psychologists, psychiatrists, community corrections officers and others are all considered before a judge makes a call. Detention or supervision, in or out. If it is out, how long is the supervision and on what conditions? And if it is in, then we'll see again in a couple of years. It is through that process in 2022 and again in the last few weeks that the truest insight into the psyche of Stewart Gorham has been revealed. And to be honest, it is terrifying. And not just because of what he's done and why, but what he openly admits he intends to do if he is ever released. Most of that insight comes from reports from Dr. Gosia Wanaroska, a forensic psychologist who specialises in assessing WA's worst offenders. These insights from her came from a report she wrote just 3 months ago. Gorham, she said, was pleasant, cooperative, relaxed. And in this mood, he told her that he hated adult white males, that he would have no problem with inflicting pain, raping or killing another person, and was closer to doing that, in his estimation, than last year. And if he ever gets out of prison, he told the doctor how he believed that day would play out. He will look for a victim within minutes of being released from prison, she relayed. He would hide in a prison car park, waiting for the first opportunity to attack a vulnerable male walking to his car. This could be a prison officer or member of the general public. He stated he would attack the person from behind and bash his head on the concrete. He stated that once the victim was subdued, he would anally rape the victim, and if he had sufficient time, he would then kill the victim. He stated he would then wait for police to shoot him during the confrontation. In Gorham's own words, "I wouldn't even make it to the gate before someone is dead." Tom, some of the decisions judges have to make on these dangerous offenders, are difficult because in the back of their mind they must know, on one hand, the implications of potential reoffending, on the other, keeping someone in prison who could be on their way to redemption. This one, though, Stewart Gorham, that must have been one of the easy ones when you hear that.
You'd think so. I mean, he's a category on his own, and I don't think that there's anything marginal about his case. A lot of these decisions that come before the courts are marginal, and sometimes you think, the judge has obviously made a wrong decision there. Like that guy's like Pendragon, remember him? Mm-hmm. And when he was released, I mean, everyone was saying it'll last 10 minutes. But 3 years later, he's still out. No offences. So sometimes they surprise you, and I think that the decisions are justified. Sometimes they're not, and judges end up with egg on their face. That's why they're very cautious about these things. Yep. But I don't think a judge would need to be very cautious to release this bloke Gorham. But
and the decisions, I mean, they obviously, as judges do most of their working life, they hold a person's freedom in their hands. But in these cases, in dangerous offender cases, that's after they've served their time. So keeping someone inside after they've served their time, that must be a judicial pressure all of its own, I would think.
Well, it is, because a judge arrives at a sentence, and the accused works out whether he wants to appeal against that. If it's too long, he wants to take it to a superior court. The prosecution also have a right of appeal. If they think it's too short, they take it to a superior court. And ultimately we end up with a sentence that suits everyone according to law. And you do that sentence, and then there's an application waiting for you saying, well, hold on, we're going to have another look at this. Puts you in a position of double jeopardy, really. And I think that's the sort of thing that has been looked at in a number of cases, and of which you're no doubt aware.
Yeah. So it was Justice Anthony Derrick that had to make the decision on Gorham. And as I said, he made the decision that most people would. He needs to stay locked up. In keeping him locked up, Justice Derrick noted that Gorham was a sexually deviant sadist with psychopathic and narcissistic traits who had refused any treatment for many years. Of his threats to murder on the steps of Casuarina Prison, Justice Derrick stated he did not doubt the genuineness of his expressions of intention, and he urged the prison to keep the closest possible eye on Gorham, because he will likely never see the outside world again. Not to further punish him, but to protect the rest of us from him. Which is where the High Court comes in. In September last year, WA's dangerous offender laws, as they now are, after being expanded by Parliament, were challenged as unconstitutional before the country's highest judges. The appellant in that case was a man called Peter Garlett, who was not a killer or a rapist, but an armed robber. He fell, or that his offences fell, under those expanded dangerous offender laws, and he was deemed by WA's courts dangerous enough to keep inside. But that was appealed to the High Court as a breach of his human and civil rights. It was a challenge which the judges of the High Court ultimately knocked back, because they ruled that the act was designed to protect the community and therefore did not constitute punishment. But not all those High Court judges agreed. Justice Stephen Gageler, in his dissenting judgment, wrote that if robbery is sufficient to justify empowering a court to order preemptive detention in custody, it needs to be asked, what offence is not? Justice Gageler would have ruled WA's high-risk serious offender laws were unconstitutional, which would have meant one prisoner, Peter Garlett, deemed by WA courts to be too dangerous to be released, would have been let out, and potentially many more after him. Sound familiar? Justice Gageler is now the High Court's Chief Justice. And it was he who, a month ago, ruled that the indefinite immigration detention of some serious criminals, and some not so serious, was unconstitutional. And so 140 of those have been released. He ruled, and all his other judges agreed, that because those immigration detention laws were not designed to protect, but to punish, then they should be overruled. And we've all seen the firestorm that has raged since. Tom, what did you make of that High Court decision and the political fallout that's come after it?
Well, I think the most recent one was decided 6-0 against the government because it involved constitutional issues, and there were straight constitutional issues. The WA Parliament is at greater liberty to make those kind of laws because they're not bound by the strictures of the Constitution. I won't go into exactly what they are, but they do say that only courts can inflict punishment and that politicians can't. Mm-hmm. So I think that the way that the regime was structured in relation to visa applicants who are effectively stateless and that there was nowhere they could go and had to be detained indefinitely was unconstitutional. So that's where that one went, and that's why it went that way. Mm-hmm. But I think that the storm, as you've called it, is really being overdone. There's 140-odd people being released into the community. Some are not serious offenders at all. Mm-hmm. They're just people who've got nowhere to go. These are not people who, in the recent history, really have done anything that's gone unpunished. I mean, they've done their time. They're just trying to find somewhere to send them. So to have 140 on the streets sounds a lot, but when you go back, you think, I can think in WA alone, there's probably 50 paroled or murderers who've done their time who are walking the streets. They could be living next door to you and you'd never know. That hasn't caused huge public insurrection. There's probably a couple of thousand child rapists out there on the streets in Western Australia alone who have been released from prison, no hoo-ha about that. And so it goes, armed robbers, drug dealers, everything like that. As I said, with a few exceptions, people like Gorham might be that, they all get out one day. Yeah. They all get out one day, other than murder. And, the fact that there's 140 more of them Australia-wide out there doesn't cause me any cause for concern because we're doing it every day. If you look at the figures, I'm just talking in Western Australia, if you looked at Australia-wide, there would be hundreds of murderers out there walking the street who've been paroled or done their full time. There would be tens of thousands of sex offenders, child sex offenders, walking the streets. I don't think 140 more people, not all of whom are serious offenders, is going to augment that to any alarming number at all. So I think we just need to sit back, take a breath, have a good lie down and just take it easy.
And I mentioned the politics of pedophilia earlier. I mean, the opposition in this case have obviously played their trump card, and one that the opposition leader has been playing for most of his political career is the politics of fear. If you tell people that they're going to be they're going to be mown down in the street or kidnapped or whatever, a lot of people sit up and listen, and then you've got the figures and you've got people reoffending. I mean, it's as you say, the reality of it is probably nowhere near as serious as the headlines would suggest. But when you've got rhetoric coming out of Canberra about that, then it's hard to then not report on that as well.
Well, it is. I mean, but the reality of it is that it has not to any significant extent increased the degree of lack of safety that already exists in the community. Sure, there's some allegations that some of them have reoffended. None of those have been proved yet, but even if they were, I mean, compared to what's going through the courts every day, the sort of insurrection and level of assaults, drugs, and the sort of things that these people are said to have committed, compared to what people who aren't refugees, who aren't released detainees, are committing every day relentlessly and remorselessly, it's of no cause for concern at all. And you're right, it's the politics of fear. Every single member of the opposition, Michaela Cash and that guy Dante, and they're coming and say, the government's under a duty to keep us safe. We need to be kept safe. Well, we're no less safe than we are on a daily basis walking the streets with the people who aren't detainees.
And what worries me when stuff like this happens is that then laws are drafted on the back of that fear or that confected outrage that could then there's no way you can tell me that the Labour Party had all this ready to go, and in 4 weeks they've just fine-tuned these new laws that were rammed through the Senate this week that basically say some of those, the more serious offenders, those who committed, I think it's committed crimes that had a maximum of 7 years, we can re-detain you now. I mean, surely they're now going to be challenged as well, those new laws, you would think.
I think that's right, and but I think it's mainly the terrorist offenders who are in jeopardy of going back in. The vast majority of those people who've been let out won't be affected by these new laws. The vast majority of them, and this is just a knee-jerk reaction. And as you say, laws that are fashioned on the back of a single decision, a single incident, are useless, and they're just political capital. I remember a few years ago there was a drunk driving law called Jess's Law brought in and said, because a poor girl got hit by a drink driver, and they said, well, if someone's drunk, they're going to be deemed to be this, and we'll call it Jess's Law. I mean, it's been used once in the last 20 years. Yep. I mean, it's a rarity. It's just political capital.
Yeah. Well, thanks, Tom. Again, always interesting and insightful to chat to you, and we probably won't do that before the festivities descend upon us. So thanks for your time this year. Have a great break, and hopefully we'll speak to you in the new year.
No, I'm sure I'll speak to you in the near future anyway. It probably won't be recorded, but
I hope not. I hope that one we can keep to ourselves.
Okay, mate. I'll see you soon.
Cheers. And thank you all again for joining us on Caught in the Act. If you've got any questions or cases you want explored, obviously, please email us at caughtintheact@wanews.com.au. And remember, if you want to know what's going on in court, don't get caught short. Get caught in the act instead. See you next time.